I'm David Findlay and I'm a solicitor with the Crofting Commission. I provide the Crofting Commission with legal advice. I also represent the Commission in appeals before the Scottish Land Court. And I provide the Commission with a whole range of advice, not just crofting law, but also relating to areas such as data protection, freedom of information, and general public and administrative law. There's been a lot of talk recently about the status of a crofter, whether a crofter is an owner-occupier crofter, whether a crofter is a landlord of a vacant croft, or whether a crofter is just the owner of vacant croft land. This has come into very sharp focus because the Crofting Reform Scotland Act 2010 created this new status of an owner-occupier crofter, which essentially is a status that is similar to a croft tenant, except that the owner-occupier crofter is the owner of the croft land. By contrast, a croft tenant is obviously the tenant and there is a lease there. However, a number of problems have arisen because the definition of owner-occupier crofter that is contained in crofting legislation does not cover everybody who is the owner of croft land. It leaves a number of people out of that definition, and unfortunately these people cannot be classified as owner-occupier crofters. The main condition that you have to meet to be an owner-occupier crofter is that you have to own all of the croft land. You also have to be buying the interest of the owner-occupier crofter rather than specifically the interest of the landlord of the croft. That means then that somebody who is purchasing a crofting estate will not become an owner-occupier crofter. Similarly, somebody who is purchasing a part of a vacant croft will not be an owner-occupier crofter. Usually somebody would become the owner of vacant croft land if they are purchasing just part of a croft. So the usual scenario would be that a crofter exercised the right to buy perhaps back in the 1980s or 1990s and then sold bits of the croft to different people. And now perhaps you're in the position where you now own one of these bits of the croft. It may be a field, it may be a couple of fields, and somebody else on the other side of the road owns a field that's also part of the croft. These people will not be owner-occupier crofters simply because they do not own the whole of the croft. Another situation where somebody would not be an owner-occupier crofter would be the following example. A crofter exercises the right to buy and becomes the owner-occupier crofter. The owner-occupier crofter then perhaps lets the croft to a spouse or a family member and creates a croft tenancy. That family member then renounces the croft tenancy. Because the original owner-occupier crofter is now the landlord, albeit that the croft tenancy has been renounced, that person will remain as the landlord and will not be an owner-occupier crofter. Somebody who is the owner of a part of a croft would be usually referred to as the owner of vacant croft land. Sometimes it'd also be referred to as the landlord of a vacant croft, though the better term is generally just the owner of vacant croft land. So usually the reason why somebody is not an owner-occupier crofter is because they don't own the full extent of the croft. But there are some other situations where somebody could not be an owner-occupier crofter, but they perhaps think that they are. This could be, for instance, where the croft was purchased before 1955. In that case, because the purchase took place before the 1955 Act, the person cannot be classified as an owner-occupier crofter. Generally, where a person purchases the full extent of a croft as registered, that person will be an owner-occupier crofter. But there are exceptions. For instance, if you are buying just the landlord's interest in a croft that is already let, then you will not become an owner-occupier crofter. Or if you're purchasing a crofting estate, you will be purchasing all these crofts that could be owner-occupied crofts, but because you're buying just the landlord's interest, you as an individual do not become an owner-occupier crofter. So it's important to be aware, and particularly to seek legal advice in situations where you're buying the full extent of a croft as registered in the Crofting Register, but you may still not be classed as an owner-occupier crofter. If a person is in this situation where they have purchased a croft that was originally purchased prior to 1955, it is difficult for that person to change their status from the owner of a vacant croft to an owner-occupier crofter. One way that it could potentially be done would be to create a croft tenancy and then for the tenant to purchase the croft and become an owner-occupier crofter. That involves, however, an element of risk because you're entrusting the tenancy to somebody else. It could also have various tax and other consequences, so the Commission would always say to somebody who is considering that they should seek specialist legal advice before doing anything that could potentially change their status. Sometimes somebody will buy a decrofted house site and they will do so on the belief that they're purchasing what is in the decrofting direction, but sometimes there is a discrepancy between what's in the decrofting direction and what is in the title deed. For instance, the title deed can include an area of land that goes beyond what is in the direction. The legal effect of that is that somebody becomes the owner of a small piece of vacant croft land and are commonly referred to as a landlord of vacant croft land. Every case where somebody is not an owner-occupier crofter has to be looked at in terms of its own facts and circumstances. In a situation where somebody, for instance, purchases slightly more than is in the decrofted area, there are a number of things that could be done to rectify that situation. For instance, the person who has purchased this bit of croft land could apply to decroft it. And that would have the effect of taking that bit of land out of crofting tenure completely. It is important for people to understand that the Crofting Commission no longer administers crofts and grants. If anybody has any questions about grants or subsidies, they should go to the local ARPID officer because ARPID is the body that is responsible for grants and subsidies. There are a number of consequences if you are not classified as an owner-occupier crofter. The first and most important of these is that the croft is regarded legally as vacant. If you're an owner-occupier crofter, the croft is not regarded as vacant, so it's similar to having a croft tenancy, that the croft is not vacant, and so the Commission would never be in a position to ask for letting proposals. The second main consequence of not being an owner-occupier crofter is that you will not be able to make certain applications to the Crofting Commission, which only an owner-occupier crofter can make. The third main consequence of not being an owner-occupier crofter is that you may not be eligible for financial assistance, which is available only to owner-occupier crofters and croft tenants. Most crofters, when they buy their croft, will buy all of their croft, but there could be some situations where a crofter does not buy all of the croft at one particular time. If a crofter doesn't purchase the whole of the croft at any particular time, but at a later date purchases the remainder of the croft, then at that later date, the crofter should become an owner-occupier crofter. So there's no need to purchase the whole of the croft at one time in order to become an owner-occupier crofter, because you can gain that status later on at the point that you become the owner of all of the croft land pertaining to the croft. If somebody purchases part of the croft and then purchases the remainder of the croft at a later date, there's an obligation to inform the Crofting Commission whenever there's a change of ownership. So if the Commission is informed at a later date that all of the croft has now been purchased, then the Commission should be able to update its register to show that person as an owner-occupier crofter. It is difficult for that person to change their status from the owner of a vacant croft to an owner-occupier crofter. One way that it could potentially be done would be to create a croft tenancy and then for the tenant to purchase the croft and become an owner-occupier crofter. That involves, however, an element of risk because you're entrusting the tenancy to somebody else. It could also have various tax and other consequences, so the Commission would always say to somebody who is considering that they should seek specialist legal advice before doing anything that could potentially change their status. Anybody who is purchasing croft land, or indeed whether they're purchasing or getting the assignation of a croft tenancy, should check a number of sources before they complete the purchase. The first source is the Commission's Register of Crofts. The Register of Crofts will set out whether or not somebody is an owner-occupier crofter, or whether they're termed landlord of a vacant croft, or perhaps the owner of vacant croft land. The second source of information that somebody should check before they purchase is the Crofting Register, which is held by Registers of Scotland. That will show the mapped extent of the croft, and you can then ask your solicitor to compare the mapped and registered extent with the extent that is shown in the title deed. Your solicitor will then check the two and see if there are any discrepancies between them. And that then brings me on to the third place that you should be looking or asking if you want to check whether the croft is an owner-occupied croft. And that is, you should be asking your solicitor to check the Register of Crofts, to check the Crofting Register, and to provide you with advice as to whether or not it is an owner-occupied croft that you are purchasing.